Gentleman from Alabama.
Mr. Chairman, in my opening statement, I said that we should not enter into arrangements with financial institutions if the terms and conditions of those agreements cannot be fully disclosed. Would you like to react to that?
Yes, sir. The terms and conditions, to my knowledge, and if you have any exceptions, I'll be glad to get information to you, but the terms and conditions of all our agreements, to my knowledge, are fully disclosed. There are of two types. There are the lending programs, such as the discount window and the commercial paper facility. Those are all public information. They're all on the website. The testimony has a list of 5 pages of websites where information can be obtained. So that information is fully disclosed. The one-off deals associated with AIG and Bear Stearns, likewise, to my knowledge, they're fully disclosed in terms of...
Are the assets and the prices paid, or the valuations, are those disclosed?
The categories of securities and loans are disclosed, and the valuation is
by categories. I mean, as to...
Well, one agency MBS is very much like another agency MBS, sir. The only distinct assets in the Bear Stearns portfolio, which are not securities, are individual loans to companies and so on. And we don't think that those companies didn't ask to be in that portfolio, and we don't want to cast aspersions on them because they happen to be captured in that operation. But if your staff would like more detailed information, we can arrange to have that information provided. But we provide quarterly information, we provide monthly information on the evolution of the portfolio and of the arrangement, and we provide quarterly fair value accounting the same way banks have to do about the valuations of those portfolios.
What, you've talked about stabilized systemically critical institutions. What's the criteria between an institution that's systemically critical and one that is not? I mean, what I've said, you have too big to fail, which implies too small to save. And to me, that doesn't seem to be a fair criteria.
Well, Congressman, you have 2 different questions there. The first is, what are the criteria for systemically critical? And we have, in each of the cases we've confronted, we have looked very carefully not only at the size and complexity of the firm in question, but also at the types of markets, counterparties, and other transactions it was involved in, and tried to extrapolate, if this firm failed, if it defaulted in the morning, how big would the implications be for the entire financial system and for the economy? And in those cases where the risks for the broad system are just too great to take, we have taken whatever measures possible to try and prevent the failure. Your second point, that it's not fair, I agree 100%. If I was a small banker, I'd be very upset about this. Small bankers don't have this protection. The too big to fail problem is a serious, serious problem, and it should be a top priority to greatly reduce this problem as we go forward with restructuring our financial system.
And one way to do that would be simply not to permit a corporation of that size. Is that right?
That would be one strategy, but other strategies include tougher regulation and supervision, or, as I mentioned before, having a tough resolution regime, like the prompt corrective action regime already in place for banks, that would allow the government to come in at a stage before default and resolve the company in a safe and sound manner.
Let me ask you this. There have been numerous reports recently that you have hired, Wall Street firms to help you value and price assets. So in many cases, those are the same firms that have relationships and business associations as well as personal relationships with the very firms that they're negotiating with. Do you disclose the identities of, say, the negotiating teams, and how do you deal with conflicts of interest, and how much disclosure is there in that matter?
Well, except for the Bear Stearns case where we had only a few hours to operate, we've done, generally speaking, an RFP type process where we accept bids and we try to make sure that the usual firewalls are in place. It's probably impossible to completely separate these firms from the other organizations in some sense, but these firms are specialists and they provide services in evaluating these difficult to value assets. And there are a number of them that, you know, we've relied on at different times to help us provide expertise that we don't have in-house.
Do you disclose the existence of who's actually on each transaction, who these consultants were?
Who was involved in the, well, typically it would be for example, in the case of New York Fed, it would have been the president of New York Fed and the chief counsel, the chief legal counsel.
No, I'm talking about, you know, the private parties that they got to help them evaluate the deals.
Yes. Well, we know who, I mean, certainly everyone knows who the principals and the leading players are in those firms. We can certainly ask if more information is needed. But these companies, of course, have to establish credibly that they do have separations between their different activities. Otherwise, nobody would use them because of concerns about conflict of interest.
Oh, thank you.
Gentleman from Pennsylvania.